This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight we're taking your calls and questions all about fighting the insurance company. If you had to make a claim, would you know what to do? What if your insurance company denies the claim? What if they're refusing to settle and you think this is just a technicality? What if they stop communicating with you at all? What if someone else's insurance company is after you about the incident and says that you should be responsible for it? Do you have to handle it? Is your insurance company supposed to handle it for you? Call in your questions, the 31 Law Call number, 256-536-0077. You can also email your questions. You can email any legal question any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull some out. We will have some of your questions about fighting the insurance company tonight. Michael Timberlake's here from Timberlake & Lee getting us started. Good to have you here.
Great to be here.
So we always like to start off the show with a little video. We pull some video off of YouTube. So this is tonight's You Make the Law Call. We've got some video tonight of it's a simulation. It's a child, not a real child, so it's a crash test dummy. So many pieces of furniture can easily be pulled over now because, you know, they're not making things of the heavy wood that they used to.
True,
That's kind of an old-fashioned TV.
Right.
Not a whole lot of us have those. But this can happen. So if something like this happens, is there a lawsuit involved? Is there a case? Or what do you see as a personal injury attorney? What do you see when you're looking at that?
Well, you know, when you typically get furniture that you assemble that, you know, from whatever store or whatever that comes to your house, or it's even delivered, it usually comes with a little bracket that you attach to the back.
That I'm supposed to.
That you're supposed to attach to the back, and potentially you're supposed to attach to the wall to try to prevent this type of tip hazard. Okay. So that is going to be one of the most important pieces of evidence in any case like this. If the manufacturer provided that, that is a piece of the equipment, and if it wasn't installed, then that can use that as a defense for any claims for product liability. You know, under the manufacturer's liability doctrine in Alabama, you have to prove the product was defective, which means unreasonably dangerous in some way, and that's what caused the problem. In this situation, the manufacturer would say, we provided the bracket with the piece of furniture that you were supposed to put on the wall. If you didn't put it on the wall, you didn't completely install the piece of furniture, and you didn't properly install the piece of furniture, and therefore we're not responsible for the injuries. Interesting.
You must see those kind of things every day. You think, a lawyer has been here. There have been lawsuits before because I recognize that there was a reason why this little gizmo, or I bet you see all kinds of things.
Oh yeah, absolutely. And you know, and we look at it all, we look at these things all the time, and you see warnings or stickers on pieces of equipment that people are saying, well, why would that sticker be there? Nobody would do that. Well, the sticker's there because somebody did it at some point in time, and the manufacturer was potentially going to be held liable for that if that happened in the future. So they can warn about a product, and you know, even if a product is dangerous, and they say for the intended use of it product, and they say, well, we warned you about it. We told you that this could happen. Therefore, it's on you for using the product.
So if you've got questions about fighting the insurance company, call in 256-536-0077. So in a case like this, is there any, so what you're imagining is somebody in the past has sued the manufacturer of the furniture.
Sure.
If something like that happens in your home, is that a homeowner's kind of case, or is that what that insurance is intended for?
Not necessarily for people that are occupants of the home.
Okay.
So the homeowner's insurance is going to be coverage, one that's going to try to protect you in the event that, you know, something happens to your home, if it's an act of nature or if it's a you know, an electrical fire or something like that, that's going to replace or repair your property in the event that something happens to it. But homeowners insurance company also offer liability coverage in addition with every homeowner's policy. Typically it's $100,000 or $300,000 worth of coverage for the homeowner for negligent acts or acts that happen on the premises, or even if the homeowner is off the premises and they do something negligent, then they can be held responsible for their actions, and the insurance company, the homeowner's carrier, will pick up the claim.
So like if my child is at your house and that accident happens at your house, would that possibly, homeowner's insurance maybe apply?
Correct.
Okay.
So if somebody was there and you said, well, this wasn't necessarily a products claim, this was a problem with the homeowner not watching the child, or they set up a design or something here that was a problem, or they didn't install their furniture properly, you could make a claim against the homeowner in that situation, and the homeowner's coverage would pick it up.
Okay. Let's talk a little bit about what things that people are typically going to run into. Car accidents, very, very common.
Sure.
Let's assume I've got insurance.
Right.
What is my insurance company supposed to do for me? If I've got auto insurance, even if I'm the one responsible for the accident, are they supposed to be representing me, getting a lawyer representing me? What do they do?
Well, automobile insurance coverage is kind of it's multifaceted. It's got a lot of different parts. People talk about they've got full coverage. Well, that's great, but what does that mean? The first type of coverage you're going to have on the car is collision coverage, and that will cover damage to the vehicle regardless of whether it was your fault or somebody else's fault. That will cover the damage to your vehicle or a total loss if it's your vehicle. You have liability coverage. In Alabama, we have a $25,000 minimum liability policy that you have to have in order to operate a motor vehicle on the road. It's not enough, but it's what we have. But that coverage will pay for injuries to anybody else that you may hurt in your motor vehicle. You've also got medical payments coverage, typically, which will pay for occupants of your vehicle that are injured. Typically, it's $1,000, $2,000, or $5,000, and they'll pay for medical expenses incurred as a result of a wreck, regardless of who was at fault, whether the driver was at fault or somebody else's fault. Then from there, you've got rental insurance, you've got tow insurance. Something we've seen recently is a type of coverage that applies if your vehicle is a total loss. And if your vehicle is a total loss, regardless if it's somebody else's fault or your fault, they'll pay for an extra 20% of the value of the vehicle to allow you to have compensation for the cost of going out and having to deal with purchasing a vehicle or potentially not being able to purchase a vehicle at the same cost that your other vehicle was. So there's some interesting things they can do with car insurance, but full coverage just means you've got all this and in place.
What if there's an actual lawsuit?
Sure.
Are they going to pay for my lawyer to represent me?
Absolutely. If you are, if you have coverage and you're at fault in a wreck, then your insurance company will pay for the lawyer to represent you. They will pick up the cost of defense. Now, they get to assign the lawyer that represents you. You don't get to go out and pick out one. A lot of these companies have in-house law firms that will handle claims sometimes that are, that will deal with that, and they'll be your counsel, and they'll represent you. Now, they will represent you and pay up to the extent of your policy limit. So simply because they provide a defense doesn't mean they're providing unlimited coverage. They're going to limit their coverage at your coverage. If it's 25, that's all they're going to pay, and then you could potentially be on the hook for something more than that.
But they're going to, even if they've already offered the full maximum of your insurance, they've still got to cover your defense.
Right, still they've got to cover your defense.
Very interesting. Okay, we got an email question in. This one came in from Brian. Brian wrote in, I own a rental house, and it was leased to a tenant who also had someone else living there. This other person invited a friend in, and their dog bit the friend. The person bitten is suing me, the landlord. I had no insurance on the house at the time, otherwise I could turn it over to them. I don't see where any of the blame can be put on me, because I'm not even allowed to go in the house during the lease period. Please advise.
That's a convoluted
That's
situation.
a
It's a
law
lot.
School question.
But it's a really good question, and basically we've had this case, or one of the cases that started this type of law with regard to the landlord being responsible. So you've got the tenant. If the tenant owned the dog, the tenant may be responsible. If the tenant had a friend over and knew they had a vicious dog, then you could potentially get to the tenant and the dog owner. But in order to get to the landlord, you got to prove in some way that the landlord had notice that the dog was on the premises and the dog was vicious and that it presented a danger to people coming on the premises. So this is more of a situation where if you have a tenant in a house that you know has dogs that have either caused problems or of a particular breed that makes them dangerous, then the landlord can potentially be held responsible for injuries caused by those dogs.
Wow. Can a landlord make a tenant get rid of a dangerous dog? I guess if you're going to be held responsible for it, I guess so.
Absolutely. And what you look into a situation is that, the landlord's, going to control the lease. And if the dog's causing a problem or the dog is dangerous, then they have a right to, to evict the tenant. Okay.
And the dog.
And the dog.
We've got Deborah on the line with a question from Huntsville. Hi, Deborah. Thanks for calling. What's your question tonight?
Yes, I was calling. I have a contract with a home warranty company.
Okay.
And our refrigerator went out in February. And as of this day, the compressor went out. And we've been throwing out food because it doesn't can't last because of the temperature. All right, and the water line from the refrigerator have waterlogged my floor in my den, but we end up having to cut the water off in the kitchen, and we've been throwing food out because we don't have no other way to keep it. They're responsible for my floor, and because of the waterlog, they said they wasn't. And also, the refrigerator since February with that compressor been out, and they finally had one guy to come out last week, and he said he ought to probably be in 2 weeks. So this been going on since February. Wow. What can I do as a citizen since this been going on? We done lost so much money on food.
Wow. Yeah.
Right.
And the floor damage, I guess.
Well,
too.
yeah. I mean, you'd have to look at the contract. In these situations, especially with a warranty claim and some of these home type warranties, we always tell people, look, make sure you understand what you're giving up if you're going to sign off on a warranty, especially on like a new home warranty. Most of these contracts require that you disclaim any right to sue them, for any of your common law remedies, which would be, warranty of workmanship or things like that. In a situation where you've got a home warranty here, you're going to look at the particular language of that contract to determine what exactly they're going to cover. Is it just the replacement or the repair, the reasonable repair cost of that situation? And I don't know why it would take them so long to figure this out, but maybe it's they couldn't get the part. But you'd have to look at that to see if the way they handled that situation was reasonable in terms of replacement. In terms of collateral damage, like the damage to the floor or things like that, again, that's going to be something determined by the language in the contract. The contract could say, we'll cover replacement of the refrigerator or repair of the refrigerator, but we don't cover collateral damage or additional damage. You just have to look at that and see what the situation is.
Very interesting. Good luck with it, Deborah. We're going to take a quick break. Be right back answering more of your questions about fighting the insurance company. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Back to 31 Law Call, I'm Sharon Doviet. Tonight we're answering questions about fighting the insurance company. We've got with us Michael Timberlake from Timberlake and League. And did you know we're also streaming live on Facebook? So if you're ever out of state or you've got family that live out of state, like the folks that were just writing into us from Colorado and said Happy Father's Day. Happy Father's Day, Michael.
Right. It's 67 degrees in Colorado. Thank you for saying Happy Father's Day.
It's steamy here, so thank you very much for that. We had somebody call in with a question. Some people are very shy and they're afraid to go on TV, even just the voice. But she had a very good question. You too, I know. Does she need an umbrella policy if she already has homeowners insurance and automotive insurance?
Yeah, so that's a great question. So basically, if you have automobile insurance, it'll cover your liability for you when you're operating a motor vehicle, and you have homeowners insurance that covers you for liability on your property or off your property. Is there any other type of coverage that you need or you want to consider when you're trying to protect your assets? And the answer is yes. All major insurance companies sell what we call an umbrella coverage, our personal liability umbrella. And basically what that does is it will take the coverages that you already have and provide a secondary coverage of, typically they come in $1 million increments, so 1 million or 2 million that you can provide to protect yourself and your family if somebody in you or somebody in your family does something that injures someone else. Now, the benefit of this is huge because you don't ever have to typically worry about whether you're going to do something that exceeds your insurance coverage. Well, you do, but that's a lot of coverage to go through. But it also provides you coverage for anything that you may do, on your property, in your car, or somewhere else. So it protects your assets that you have in the bank so that you're going to have enough insurance so that somebody's not going to come after your car or try to get your house or try to get your retirement account if you should happen to do something and injure somebody else severely.
And bad things happen all the time.
Yeah,
right?
and
happens.
Those policies are cheap. I mean, for $100, a couple $100 a year,
really,
you can increase your insurance to $1 million, maybe $2 million.
Nice. That is cheap.
Yes.
That's great. Let's talk a little bit about dealing with your own insurance company. Is your own insurance company, are they on your side? Are they not? Once you have a problem and you want them to pay money, whose side are they on?
Well, they're on their side. They take their premiums, and then when you make a claim, they have a obligation to deal with you in good faith and fair dealing. But what does that really mean? And that's a lot of situations that we see all the time. Your insurance company doesn't have the obligation to take on a claim. Like if you're in an automobile accident and somebody else injures you, you've got to prove your case. Your insurance company is not responsible for proving your case. Sometimes they'll pay for the property damage and go against the other insurance company and recover that and potentially your deductible. But they're not going to investigate a case for personal injury. They're not going to make a claim for personal injury. They can't even tell you how to make a claim for that kind of situation. So, they can provide some information, but they really can't help you that much.
So that's where personal injury attorneys come in. So
correct.
Everything from car accidents, medical malpractice kind of things. So how does somebody afford that?
Well, personal injury attorneys like our firm, we work on a contingency fee basis. So you're not going in there and writing us a check up front for what it costs us to represent you. We work on a graduated contingency fee basis based upon the type of claim. And workers' compensation claims are set by law at 15% of the recovery. Automobile accidents are typically a third to 40%. Medical liability claims can be 40% or more. Premises liability claims can be a little bit more. And the reason that there's a different fee schedule is because of the difficulty and the expertise and the complexity of these types of cases. Workers' compensation is traditionally a no-fault claim, so usually you're looking at what are the extent of the injuries alone. Car wrecks can be different. It can be complex between how many vehicles are involved, but it's a very common type of insurance claim to make, and so there are typically claims that are resolved out of court.
What percentage would you say of injuries where lawyers are involved, what percentage actually get lawsuits filed? Because you don't have to do that, right?
Yeah, you don't have to file a lawsuit. You can settle your claim out of court. I would say 20 to 30% of the claims
get an actual lawsuit filed.
Get an actual lawsuit filed. And lawsuits are filed really for one of three reasons. Who was at fault? Why was, it was the plaintiff at fault in some way? Was the injured person at fault in some way? Is there clear proof that the defendant, that the potentially responsible party caused the problem that caused the injuries? That's typically one reason a lawsuit can get filed. Two is this whatever incident that happened, did it cause these injuries? Is this something that really was caused, or is there some pre-existing problems or long-term chronic problem that somebody had that wasn't caused by the wreck? And then third thing is really just a dispute on value. Is what the insurance company willing to pay to settle the case? Is it reasonable given the circumstances and the injuries that we have?
So you're thinking 20% of those that are legitimate cases actually get a lawsuit filed?
Sure.
What percentage of that 20% go to trial, would you say?
Oh, I would probably say, 85 to 90% of cases get resolved at some point. So maybe half of the ones that
actually go to trial.
Actually go to trial. I don't. Maybe not that many actually.
Okay, the insurance. You guys have said before that if you have a trial, the jury doesn't even know about the insurance.
Sure.
What is that about?
Yeah, I mean, it's one of those things. We've tried cases and we've had results, and they were good, but not as good as we wanted. And we talked to the jurors after the fact, and they would say, well, you sued Miss Smith, and she seems like a nice lady, and I don't think she really meant to do this harm, but she was careless and she did cause an injury, and so we really just didn't want to hurt her. And first thing comes out of her mouth is that, well, we're not hurting her, you're hurting her insurance company that she's paid premiums to, so that they would have to pay full value for whatever injury she causes. And a lot of times they're surprised by that, but that's part of the rules, as the rules of evidence. When you go into court before a jury, we don't get to tell the jury that Miss Smith has insurance or how much insurance she has. That's something that the law says would typically lead a jury to award what they think is something unreasonable or something higher than maybe what the evidence shows. We think that the opposite that comes in play is that if they don't know there's insurance, they're probably not going to award as much as they would or they would think would be fair if they knew an insurance company was involved in the case. So that's kind of the rub both ways.
Okay, sounds like the insurance lobby.
The insurance lobby is very strong in Alabama.
Okay, we're going to take a break. Be right back answering more of your questions about fighting the insurance company. Stay with us. If you haven't gotten your questions answered tonight, and we've got some more coverage, more answers coming, here's how to reach Michael Timberlake with Timberlake & League. They are personal injury attorneys, so everything from car accidents to medical mistakes. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon practices family law right here in Huntsville in the Tennessee Valley. She does a great job with this. Child custody cases, divorce, child support cases. She does all kinds of family law. 256-539-7337 or SharonFamilyLaw.com.
We haven't talked about uninsured motorist coverage. There's so many people out there on our roads that don't have insurance, no matter what the law says.
Yeah, we talked about mandatory minimum coverages or what somebody else has to have. But if somebody's got $25,000 or they're running around out there with no insurance, it can be a real problem for you if something happens. So in Alabama, you can protect yourself, your family, the occupants of your vehicle by purchasing what we call underinsured or uninsured motorist coverage. And that is just simply coverage that protects you, your family, the occupants of your vehicles if somebody else that doesn't have insurance or doesn't have enough insurance hurts you. You can purchase it in large amounts, up to $100,000 or $200,000 per vehicle. So you can provide yourself a lot of protection in the event that somebody else is running around out there without coverage or without enough coverage.
We also got a call in from Phil who said to tell you thanks for helping him out with his case.
Well, I'm glad he got it worked out.
Sounds like you did well. Thanks for all your calls and questions tonight. We'll see you next week.